Hello friends, welcome to this session on Information Technology Act 2000. We all know that rapid evolution of technology has changed the way in which we live our lives. The communication systems have reduced the distances between the nations, and as a result of this, the businesses are now not confined to the boundaries of their home countries. In order to keep up with this pace, the businesses now have started relying on electronic records instead of traditional methods of bookkeeping. Moreover, the transactions undertaken by these businesses also have shifted to electronic medium. In such a situation, one of the biggest challenges that the parties which rely on electronic records is that the electronic records were earlier not accepted as evidences in legal proceedings which they might have to face. To eliminate such problems, the Information Technology Act 2000 was enacted by the Parliament in the 51st year of the Republic of India. In today's session, we will learn about the various definitions of electronic media given in the Act as well as the provisions related to the digital signatures. The main aim of this Act is to provide legal recognition for any transaction which is carried out with the help of electronic data interchange and other means of electronic communication. The Information Technology Act is applicable to the whole of India as well as in such cases where any offence has been committed by any person who is outside India. The provisions of the Act are not applicable in the case of 1. Negotiable instrument, 2. A power of attorney, 3. A trust, 4. A will or any other similar document, 5. Any legal contract for the sale or conveyance of immovable property, 6. Any other class of document or transactions which have been notified by the central government. Before proceeding further, it is important to understand few aspects of this Act. A. Various definitions of electronic media given in the Act. 1. Computer. A computer includes A. Any data processing devices which help in performing logical, arithmetic or memory functions by manipulating electronic, magnetic or optical impulses. B. Input, output, processing, storage or communication facilities used with the computer system. 2. Computer system. Input and output support devices which are used in connection with external files that contain computer programs, electronic instructions, input and output data and aid in performance of logic, arithmetic, data storage and retrieval, communication control and other functions are included in a computer system. 3. Characteristics of a secure system. A computer system can be said to be secure when 1. It is reasonably secure from unauthorized access and misuse. 2. Provides reasonable level of reliability. 3. Performs correct operation with intended functions. 4. Follows generally accepted security procedures. 4. Computer resources. Computer resources include A. Computer, B. Computer system, C. Computer network, D. Data, E. Computer database, F. Computer software. 5. Computer network. When a computer is interconnected with one or more computers with the help of satellite, microwave or any other medium, it is referred as a computer network. It should be noted that even if the interconnection between these computers is not maintained continuously, then also it would be referred as a computer network. 6. Access. When any user gains entry, gives instruction or communicates with the arithmetic or memory function or the resources of the computer, its system or computer, then it can be said that they have gained access. 7. Originator. Originator is that person who sends, generates, stores or transmits any electronic message or causes any electronic message to be sent, generated, stored or transmitted to any other person. Such a person who receives this information cannot be an intermediary. 8. Message. A message is an electronic record or information that has been generated for transmission. 9. Intermediary. An intermediary is any person who on behalf of another person receives, stores or transmits that message or provides any service with respect to that message. 10. Addressee. Addressee is that person who would be receiving the electronic record sent by the originator. The intermediaries which are involved in this procedure cannot be considered as an addressee. 11. Data. Data includes information, knowledge, facts, concepts or instructions which are being prepared or have been prepared in a formalized manner. This can be processed or are stored with intention of being processed by the computer system or computer network. It can be stored internally or externally in the memory of the computer. 12. Electronic form and electronic record. When any information which is generated, sent, received or stored in media, magnetic, optic, computer memory, microfilm or any similar device, then such an information would be said to be in an electronic form. When the data, record, data generated, image, sound which is sent or received is in electronic form, then such information would be referred as electronic record. 13. Affixing a digital signature. Affixing a digital signature is adoption of any methodology or procedure by a person for the purpose of authenticating an electronic record by means of a digital signature. 14. Key pair. Key pair is a combination of private key which is used to generate a digital signature and its mathematically related public key which is used to verify a digital signature. Such a key pair which is secure is known as asymmetric crypto system. 15. A subscriber. Subscriber is that person in whose name the digital signature certificate is issued. 16. Adjudicating officer. It can be any officer who is not below the rank of the director of the government of India or an equivalent officer of the state government. The above definitions form the background of the Act. In actual business transactions, the provisions which relate to the authentication of digital signatures and electronic governance play an important role. Now, let us discuss the provisions related to digital signatures. A certifying authority follows a specific practice to issue a digital signature. These practices are included in the certification practice statement. An electronic record is legally accepted only when they are digitally signed by a certifying authority. Let us understand the provisions which are related to digital signatures. Authentication of electronic record. The electronic record that is generated has to be authenticated to make it legally acceptable. For this, a digital signature needs to be affixed on such an electronic record. Any subscriber can authenticate an electronic record by affixing his digital signature. For the purpose of authenticating any record, the subscriber has to use asymmetric crypto system and hash function. This envelopes and transforms the initial electronic record into another electronic record. The hash function is used for algorithmic mapping or translation of one sequence of bits into another sequence which is generally smaller. The record that is generated is known as hash result. It should be noted that whenever the algorithm is run with the same electronic record, the same hash result would be generated. This ensures that no two hash results are same and also enables verification of the electronic record by any person who has the public key of the subscriber. Recognition of information as electronic record. Any document, information or any other matter in writing or typewritten or printed shall be deemed to be an electronic record when such an information is made available in electronic form, as well as it is accessible for subsequent reference. Legal recognition of a digital signature. In case where the law provides that the information or any other matter have to be authenticated by affixing signature or the document has to be signed, then in such a circumstances, if the central government permits, then the digital signature can be affixed. Before we wrap up this session, let us revise what we studied. In this session, we covered as to why the Information Technology Act was introduced, and we also saw where the provisions of the Information Technology Act are applicable and also the cases where the provisions are not applicable. We also covered the various definitions of the electronic media as given in the Act. Then we also covered the provisions which are related to the digital signatures, where we saw as to how the electronic records are authenticated. Further, we also covered as to when information would be recognized as electronic record. Lastly, we also saw as to when digital signatures are legally recognized. I hope that you understood the various aspects that we discussed today. Thank you.